Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, May 7th, 2026 at 9:05 in the morning. So we're here to look at amendment to H 648, which we will be getting today. It was sent back, received work yesterday, so it'll be sent back to the committee tomorrow, today. So this is a two-part. There's piece in there that deals with the kiosks, the crypto kiosks. There's also, I think, we've talked about this before. There's what's called the merchant cash advance that we're starting to see is becoming pretty prevalent around the country. And I know I've received those emails saying you've been pre-approved for a $200,000 loan, line of credit, all made by companies that have no license in the state of Vermont, probably anywhere else, to be and I guess I'm assuming they're somehow figuring they're not alone. I don't know how they do that, but and we'll hear more from DFR. Unfortunately, Maria can't be with us this morning to walk us through the language, but Aaron is mine being a surrogate and walk us through
I will do my best.
I know you've been working with Maria on that.
See if I know how to do this. Yeah. Aaron, which of the two should I make?
It's the one with my first name capitalized, I think. Like I said, I think. Can you see that?
Yes.
All right, good morning. For the record, I am Aaron Ferentz, Deputy Commissioner from the Banking Division at DFR. Thank you for having me to discuss these potential amendments to House Bill 648. As was introduced, there's two main components to this. One relates to virtual currency kiosks, and the second relates to the merchant cash advance language, something that we've coined in this language to be commercial financing contracts. So I will just walk through the amendments here. And again, they all relate to the potential for a ban on those kiosk machines. So you can see the first item in this amendment would be to strike out section 11 of the Senate version of the bill and replace it with this language. All that's done in this particular section is remove the references to essentially buying virtual currency through a money transmission kiosk. Because if you did ban that action, then you would no longer need that language in the statute. So most of it is actually right here on line 16 of page 2 for a transaction that does not involve virtual currency, that would no longer be needed. And then on the following page, the entirety of paragraph B would be removed. Any questions on that?
Yeah. Madam Minister, so what's the general purpose here? So what's the big scheme purpose of these amendments?
These amendments relate to the request to draft language which would ban virtual currency kiosks in Vermont.
I got it.
So I'm not sure if you're aware, but the Senate version of this bill extended the moratorium for one additional year starting on July 1st.
I saw it.
This language would essentially undo that and just ban them as of July 1st.
Thank you.
That came from the Senate.
That came from the Senate.
No,
What came from the Senate was an extension of the moratorium.
1 year.
Sorry, yes, that's
this is an amendment that we
The
would,
proposal that we may, if we need to further amend the amended version and send it back to the Senate.
Okay, I got you. Thank you.
Yes, sorry.
Can you remind me what our action was?
We did nothing on.
Got it, yeah. That's why I don't remember.
Any questions on that? Okay.
Okay,
The second action would replace a new section 14, or excuse me, section 14A from the Senate version amends the required disclosures that are required for virtual currency kiosk transactions. Again, it's removing language which essentially talks about these virtual currency kiosk machines in this state and the transaction through. So again, it is all language that would just no longer be necessary. In that particular case. Talks about what they would have to.
yeah, so just getting back, so, I understand the general purpose is to ban the use of crypto kiosk.
That's what this language would.
That's what, like, and so we're keeping those, we're keeping money transmission, but not crypto.
That's correct.
Got
That
it.
there's the distinction between a virtual currency kiosk, which is a form of money transmission kiosk. But the idea would be that if Western Union wanted to set up a machine that would accept cash to then deliver to someone else.
Okay, thank you.
Okay, but it's still regulated by TFR.
Yeah.
Kind of see. Bless you. So there's, there were all these requirements over the receipt that you needed to provide at the kiosk machine that would all be removed. Customer warnings, the procedures about, what the kiosk operator would need to do when they were interacting with the consumer. That's all the language that's being removed, potentially with this amendment. Section 14B is a new section. And that is actually where the language to do the ban itself would be input. So. Let's see, section 2577, virtual currency kiosk prohibition would be amended to prohibit virtual currency kiosks. No person shall locate, operate, or otherwise make available for use or allow a third party to locate, operate, or otherwise make available for use of virtual currency kiosks in Vermont. The person shall offer, facilitate, or engage in whole or in part, directly or indirectly, virtual currency business activity via a money transmission kiosk in Vermont. Any questions on that language? What we did leave in this particular section is just there's language here that would talk about the existing machines in Vermont, that their registration would expire as of July 1st of this year. This language is stricken because that talks about the daily transaction limits, the licensing requirements, all sorts of other additional regulatory work that we've done in the last couple of years, which would no longer be necessary if you decide to do that. We did keep in refund language just to protect the customers of these machines through the period of time that they've been operating. The refund language was very strong, so we still felt that it was important to protect any customers who might have been felt they were victimized in that way could still get refunds based on the language that was passed last session. That is on page 15 of the bill. Refund for customers, that stays in. Fee refunds for existing customers. We did add in this section 4 on page 16, starting at line 9. And that section requires that the operator of the machines keep records for a set period of time, at least through July 1st of 2031. Does give us the power, if we do request it, for them to keep that longer, but that would just be to ensure that if there are any questions about any refunds or any activity, we would have access to that information. Questions on that record keeping requirement? The remainder of this provision, I believe, is just striking statutes that would no longer be necessary without any kiosks in the state. So that was all of the provisions about the kiosks and the potential ban.
This goes back to a report that you did a couple of years ago on how this, right, this is not something that, we've talked about this. Or I just don't want to, this is not out of the blue. This is something that we've been watching and.
Well, I would say that DFR has been regulating this space for a number of years. We had the kiosk registration. We input some limits on the transactions. We did work last session to modify some of that. This is language that was requested of us, so that's why we drafted it.
And we're still finding that the largest fraud or among the largest fraud that are reported to in Vermont are coming from these systems, or is that?
Well, I would actually say that because we only have 2 existing machines, the amount of fraud reported to us has gone down. Like, I don't think we've had any reports of any activity.
Okay.
So recent other states,
Nationwide,
yeah, nationwide, there's still reports of fraudulent activity through these machines. 3 other states have already passed laws which do ban those. Tennessee, Indiana, and Minnesota just bill was signed this week. I believe there are other states that have legislation pending as well.
I'm just, probably just gonna repeat what she said, putting on your DFR hat.
Sure.
It sounds like you've done some pretty extensive research on this and you found that these do more harm than good to the consumer. And that's, I'm very entrepreneurial. I'm like one of these people where I think anyone should be able to do whatever, have any sort of
Sure.
legal business possible, unless there's a reason not to. So I just want to, so it sounds to me like what you're saying is, according to your research, this is much more, it does more harm than good to the consumer, I guess.
I don't know that there's a real legitimate use for these machines. I think in 2025, based on the data that was reported to us from every entity licensed at DFR, Vermonters engaged in virtual currency exchanges for money, not actual cash, but just, it was fiat currency to buy or sell. It was over $1 billion. The amount of activity through these machines was about $400,000. So Vermonters will still have access to virtual currency without these machines.
Oh, yeah. No, I mean, I've got an app on my phone. So, okay.
Right.
Yeah. We'll still have further discussions on this.
Right. Okay, so the next part of the discussion is about those merchant cash advance, that situation, that product. So we took a look at what other states have done in the space. There's been some activity in New York, Texas, Virginia as well, and we tried to get to a situation which would help to regulate that here in Vermont. We have had people that have called DFR about these types of transactions. They are structured though as if the provider is purchasing the accounts receivable of the business and then providing cash today and then collecting that over time. It's structured based on that structure. Generally, it would not be considered a loan in Vermont today, which really limits our ability to regulate it. This language would address those concerns by pulling that activity, that commercial financing activity as defined, which we'll talk about in a second, as an activity that does require you to have a lender license in the state of Vermont, regulated by DFR. By pulling these entities within that structure, you'll then have the licensing power that we have with anyone else. So we will go through the process of vetting them to make sure that they don't have employees with criminal backgrounds. We will go through the process to make sure that they have sound financial condition. We will go through the process to fully understand who owns them. Just make sure that We know who they are before they are offering those services to homeowners. It also gives us the power and the responsibility to do an examination of their activities every 3 years. So it will put on some good, a good structure of regulation if you were to enact this amendment. Any general questions about what I just said at all?
This is same process that we used on payday lenders. We didn't ban them.
Exactly.
But we required them to become licensed in the state of Vermont. I don't think we had anything.
Not that I'm aware of. The usury caps really limit their business model, but yes, if they could, they would something like. Okay, so this fourth section here on page 19.
Oh, I'm sorry. So 2246,
Actually,
what's that a reference to?
that is a good point. That is an error. That should refer to 2247.
And what's 2247?
2247 is the new section of law that we are going to be
Okay.
adding, which has all of the requirements and definitions.
I get it.
Just so you know, this hasn't gone through editing
It's
either.
not gone through it. Yeah, we were working with Maria on this particular.
Maria's been tied up pretty much this week, so. Get this out pretty quick.
All right, so sorry, going back to section 59. This is modifying 8 VSA 2115, which is our general licensing penalty provisions. What we've done is we've copied the language in section E1 there, which talks about how if you make a loan in knowing and willful violation of state law, then you're not allowed to collect it. Okay. We've created this new section 2, which says the same thing for these commercial financing contracts. So if we can prove that you knowingly and willfully originated this type of funding in Vermont, we can go ahead and enforce it so that you can no longer collect that from the entity that you provided it to. If it's not knowing and willful, we can still go after you and just prohibit your ability to collect any interest. The provider would be allowed to collect the principal that they advanced or distributed to the recipient.
This will be going forward, right? It won't.
That's correct. There's going to be 2 effective dates for the merchant cash advance provision. The licensing of the entities themselves, we requested to go into effect in July of 27. The rulemaking authority, I think we're still working on that, either would start immediately or at the same time, but we're going to need time anyway to develop what the rules will be.
Any contracts that are in effect. They don't have to be licensed. Would the regs that you have still apply to them?
I don't believe we could say that the penalty provisions would apply to loans originated before we input this new statute in July of 27. So it would just be sort of, we have to pick a date, I guess. All right.
Does it make sense for this part of the bill to go into effect upon signature rather than July 1? I mean, it's not going to make much of a difference, but
I think that was something that I requested of when I was talking with Maria, just because
you need time.
we need time to sort of, later on, we'll talk about the rulemaking and it's sort of give some things that we'll want to do. In paragraph 3, again, there was more changes just to reflect this new penalty for commercial financing contracts. All right, so new section 60 here, which is adding 8 VSA 2247, chapter 73, which is our licensed lender statutes. This first part is adding in definitions. So we need to define what we're regulating here. So the first definition is for what's called a factoring transaction. And factoring transaction would be, let's say you're a business that has a $10,000 account receivable from an entity. A provider could factor that by essentially buying it from you for $9,000. So they're discounting that receivable and giving you $9,000 today. You'll pay them $10,000 when you receive the actual payment on that receivable. So that difference essentially is a finance charge, which we'll talk about later. So it means an accounts receivable purchase transaction that includes an agreement to purchase, transfer, assign, or sell a legally enforceable claim for payment held by a recipient of goods the recipient has supplied or services the recipient has rendered that have been ordered but for which payment has not yet been made. We do further say that a purchase of accounts receivable in connection with the purchase and sale of substantially all of the assets of a business or line of business shall not be deemed to be a factoring transaction. So if you're buying the whole business, you don't need a special license to be a. We define commercial financing in this particular context to mean sales-based financing or a factoring transaction. We further define sales-based financing in a second.
Can you give me that example you had just one more time?
Sure. So I am a business and I am owed $10,000 in accounts receivable for a service or a good that I sold. You as the factoring company will say, we can give you some financing today. We're going to buy that $10,000 receivable from you for $9,000 or whatever the negotiated discount essentially is. So that's essentially a form of financing because you're taking something that's going to pay $10,000 in the future today for $9,000.
With your bank. So, yeah.
I just made up those numbers. I'm not sure exactly.
I know you did.
Some of the transactions that I've seen are bad.
I bet.
Okay, number 3, finance chart, unless there are more questions. Sorry, I just keep answering. I'm not overstepping your person. All right, finance charge means the cost of financing as a dollar amount. It includes any charge payable directly or indirectly by the recipient and imposed directly or indirectly by the provider as an incident to or a condition of the extension of financing. It includes all charges that would be included under 12 CFR Part 1026.4 as if the transaction were subject to the same part. In addition, the finance charge shall include any charges as determined by the commissioner. For the purposes of a factoring transaction, the finance charge includes the discount taken on the face value of the accounts receivable. The 12 CFR Part 1026.4 is what's called the Federal Truth in Lending Act. We define the provider means a person who provides or will provide commercial financing to a recipient or who extends a specific offer of commercial financing to a person or to the person's authorized representative. Provider also includes the person who solicits prospective recipients of commercial financing or who presents specific offers of commercial financing on behalf of a third party. The way we've defined this provider is not just someone who is licensed to do this, but who's someone who is soliciting or web advertising, sending out mailers, or cold calling store owners in the Northeast Kingdom.
So I'm just going back to commercial financing. Got 2 categories there.
Correct.
Is that the universe of types of transactions that we're looking at, and possibility for other permutations of that?
That's the universe that we sort of see now. We'll define the sales-based financing part of it in a second.
Yeah, I saw it.
But yeah, we've seen sort of the 2 different ways that these transactions are structured. I don't know that we could think of every possible way or permutation that this could go through, though.
Okay, thanks.
Any questions on the provider? Number 5, recipient means a person that receives or applies for commercial financing or is made a specific offer of commercial financing by a provider. A recipient may also be an authorized representative of such person. Number 6 on page 22, sales-based financing means a transaction that is repaid by the recipient to the provider over time as a percentage of sales or revenue, in which the payment amount may increase or decrease according to the volume of sales made or revenue received by the recipient. Sales-based financing also includes a true-up mechanism where the financing is repaid as a fixed payment, but provides for a reconciliation process that adjusts the payment to an amount that is a percentage of sales or revenue. Sales-based financing also includes transactions structured as a sale or assignment of future accounts receivable, future revenue, or future sales.
Those are gross sales. At the end of the day, it's not good net. So that's,
Yes, it would be, yeah, it doesn't talk about gross or net at all. It's just sales, correct? So essentially, this is as opposed to the factoring transaction, which we have this actual accounts receivable that we factor to the provider. This is about sort of forward-looking accounts receivable that we expect over time and captures it within this regime.
What does the second sentence do? Why does it need to be in there?
The sales-based financing also includes a true-up
Yes.
mechanism. Because we're thinking about future accounts receivables, we may not have a steady stream of accounts receivables to be able to say that there's going to be $1,000 every month coming in. So you would need to true it up because one month you may have $1,500, for example, or $200.
And to define sales-based financing accurately requires that specificity. I guess that was what I was just curious about, if that needs to be articulated in order to.
Yeah, I think you're going to need that because the payment in this language looks at the payment, which may fluctuate based on what that activity is. So you'd want to chew it up to make sure that you don't pay more than what you expected to pay.
Okay, I sort of thought that the last clause of the first sentence in which the payment may increase or decrease according to the volume of sales, I think maybe I'm just missing it grammatically. But so that second sentence is doing something that the payment amount may increase or decrease according to the volume of sales is not doing.
Yeah, well, I think what the second sentence is saying is that there will include a true-up mechanism so that the entity will say, look, we collected X amount from you, and we will then make whatever adjustments are needed.
Okay.
Future.
Makes sense.
Paragraph 7, solicit prospective recipients of commercial financing means for compensation or gain or with the expectation of compensation or gain. System A, solicit prospective recipients for commercial financing. B, offer, broker, directly or indirectly arrange, place, or find commercial financing for a prospective recipient. C, obtain commercial financing for a prospective recipient or offer to obtain commercial sales-based financing for a recipient from a provider. D, initiate prospective recipient's interest, inquiry in commercial financing by online marketing, direct response advertising, telemarketing, or other similar contacts. E, engage in the business of selling information identifying a prospective recipient of commercial financing. F, generate or augment information identifying a prospective recipient of commercial financing for other purposes. Or G, refer prospective Vermont recipients to other persons for commercial financing. Essentially just all the conditions which were definition 8 is specific offer means the specific terms of commercial financing, including price or amount, that is quoted to a recipient based on information obtained from or about the recipient, which, if accepted by a recipient, shall be binding on the provider as applicable, subject to any specific requirements stated in such terms. Any questions on the definitions? Any further questions? All right. Section B, license requirement. A provider shall not provide commercial financing to a person in the state, extend a specific offer of commercial financing to a person in the state, or solicit prospective recipients of commercial financing extended by such provider, unless the provider is licensed as a lender under this chapter. Paragraph 2. Provider shall not solicit prospective recipients of commercial financing on behalf of a third party or present or extend specific offers of commercial financing on behalf of a third party unless the provider holds a loan solicitation license under this chapter, and such third party is licensed as a lender under this chapter or otherwise exempt pursuant to further paragraphs following. Let's see, paragraph B3 here says a lender license, commercial lender license or loan solicitation license shall not be required under this section of any of the following: a state agency or political subdivision or other public instrumentality of a state, federal agency, other public instrumentality of the United States. C, a depository institution or a financial institution as defined in 11-101, section 32 of Title 8. And B, a seller of goods or services that finances the sale of such goods or services to a recipient. Those are a subset of the current exceptions to our licensed lender statute. We wanted to pull those forward specifically to this area because we weren't sure that all of the others really were applicable to the commercial financing. And then paragraph 4, this section shall not apply to commercial financing transactions of $1 million or more that are not primarily for personal, family, or households. That same language is also found in our commercial lender statute. So if you're a non-bank commercial lender doing loans over $1 million, you don't need that special license from DOJ.
Help me with D.
So we don't rate, so if I'm an entity and I sell something to a business or a consumer, and I take payments on that sale and I don't transfer that essential loan that I've provided to the customer, you don't need a special license to do that from the state of the law.
It's like a distributor providing credit terms to a store.
Let's see. Paragraph 5, for purposes of this section, 8 VSA 2201D shall not apply. And that is the specific section that has the whole gamut of the exceptions to our licensed lender statute. We don't want that applied to this activity, we want just the exemptions above, correct? All right, paragraph C, personal, family, or household use. A commercial financing offered, extended, or otherwise provided primarily for personal, family, or household use. Purposes of regulation under this chapter shall also be deemed to be a loan for purposes of this chapter. Any commercial financing deemed to be a loan under this subsection shall be governed by and subject to applicable provisions of this title, including this section and 9 VSA chapters 4, 59, and 61. So basically, we say, if you do this, and it turns out to be for a personal reason, so essentially to a consumer, not to a business, then you'll still have to comply with all of the chapter 4 as the all sorts of restrictions in terms of the interest rate and the fees you can charge or not charge and all those sorts of terms. Chapter 59 and 61 are related to something called retail installment contracts. So, or motor vehicle retail installment contracts. So like if you go to the Toyota dealer and buy a new car, they finance it through Toyota Motor Credit. Toyota Motor Credit is that retail installment contract provider. So you'd have to comply with these other laws if you're doing it on a personal basis. You shouldn't be doing it on a personal basis, but it's protection.
Yeah.
That's kind of what I was thinking. So I thought the previous definition kind of was zeroing in on commercial transactions.
Sure.
So, and now we got something, and you can't do it for personal uses also.
Yeah, we were trying to be a little forward thinking. We were thinking of, let's say you're an Uber driver and you got an offer that someone would buy your future receivables from Uber. We wanted to make sure that that was covered and we were protecting that activity from abuse. So it might be unclear that that person would be, that would be commercial financing activity or not. If it's just so that Uber driver could pay their rent, that would be personal, family, or household use.
I see.
Has to do with gig economy.
What's, yeah, okay.
It kind of has to do with, we just wanted to make sure that we weren't overlooking or creating a
Right.
loophole too.
Yeah, totally. That's great. But so, sort of different question. Is any commercial financing need to be a loan? No, before, the sentence before. So these personal use transactions shall also be deemed to be a loan. Oh, I see, for purposes of this chapter.
Right.
So
So
there-
chapter 73 has all of the other
If you-
protections already for
If
them.
you just, your business model is just to get a gig economy, folks, you're subject to the whole licensing scheme.
Correct. And again, these are just the ideas that we came up with to put in here. If you wanted to modify those and talk about how to change it, it's totally. Paragraph D on page 25, certain automatic debits prohibited. I forget which state actually has this, but we did think it was an interesting concept. A provider shall not establish a mechanism for automatically debiting a recipient's deposit account unless the provider holds a validly perfected security interest in the recipient's account under Title 9A with a first priority against the claims of all other persons. So this would essentially require the bank that holds that deposit account to accept the security interest in that deposit account and those funds. So if they're also happen to be a provider of commercial financing to that entity, they may not want to do that. So that would make sure that these types of transactions don't just pull money out of a checking account every time that there's funds.
Can I learn about validly perfected?
Sure. I will do my best. I am not an attorney, but Title 9A has the Uniform Commercial Code, and that gets through all sorts of requirements for not just the payment of checks and stuff, but also electronic payments and how all of that would follow. So you would need a special, I forgot the name of the term, a special account agreement, also signed by the bank that is accepting that you do have an interest in these funds.
Oh, it's a term that means that there is, I think I'm getting what you're saying. So it's made clear that you have the right to have this thing.
Right, access to the funds that are going into the account.
Thanks.
Paragraph E, confessions of judgment, commercial financing contract that contains a confession of judgment provision or any similar provision is void and unenforceable. This might be, if you have questions on that, that's again sort of would be in the contract and that is also something that is prohibited in general loan contracts. Paragraph F, choice of law, jurisdiction and venue, arbitration. And so what this says, I guess I'll just read it. Where a provider enters into a contract or agreement with the recipient to provide commercial financing, such contract or agreement shall be governed exclusively by Vermont law, and any cause of action arising under such contract or agreement shall be brought in court in this state. Any provision in the contract or agreement providing that the law of any other jurisdiction shall govern or mandating that any such action be brought outside the state shall be unenforceable by any party other than the recipient. Where a contract between a provider and recipient contains an arbitration provision, such contracts shall not require face-to-face arbitration proceedings outside the state. If it does, such provision is unenforceable by any party other than the recipient. The enforceability of the remaining provisions of the arbitration agreement and the method of selecting a forum for the conduct of arbitration proceedings are as provided in the Vermont Arbitration Act, Federal Arbitration Act, and any applicable rules of arbitration. This is the provider shall pay any arbitrator's expenses or fees or any other expenses or administrative fees incurred in the conduct of such proceedings.
So, are there any material differences between the state arbitration act and the federal?
I would have to defer to the attorneys for that.
Sometimes, they're all different flavors of arbitration statute.
Yes.
Some are more protective of the potential, but well, the recipient than others.
I think what we're trying to do here is at least make it so that you could just at least do that within Vermont and not have to travel to some.
Oh, I get that. I
County
get
in
that.
Minnesota.
Yeah, that's makes total sense.
Okay, paragraph G, here we get into disclosure requirements. So, sales-based financing disclosure requirements. Number one, provider shall provide the following disclosures to a recipient at the time of extending a specific offer of sales-based financing. A, the total amount of the commercial financing and the disbursement amount if different from the financing amount, after any fees deducted or withheld at disbursement. B, the finance chart, which we've already defined previously. C, the estimated annual percentage rate using the words annual percentage rate or the abbreviation APR expressed as a yearly rate, inclusive of any fees and finance charges and determined in accordance with the Federal Truth in Lending Act, Regulation Z at 12 CFR 1026.22, as may be amended, and based on the estimated term of repayment and the projected periodic payment amounts, regardless of whether such act or such regulation would require such calculation. Now, again, we're trying to require this calculation of the APR, which would not normally be required by this law because under its interpretation, they're not loans. But we're saying use that method as if it was subject to it. And these are all the things you have to do. We use the term estimated because, again, with sales-based financing, the payment may fluctuate, which may adjust the term. So we have to make some estimates. Questions on that? I think I left about halfway through. The estimated term repayment and the projected periodic payment amounts shall be calculated based on a projection of the volume of the recipient's sales or revenue. Projected volume of sales or revenue may be calculated using the historical model as described in subdivision 1 of this subdivision G1C, or the opt-in method as described in subdivision 2 of this subdivision G1C. This is all defining how we would do that. So a provider using the historical method shall use an average historical volume of sales or revenue on which the financing payment amount are based and by which the estimated annual percentage rate is determined. The provider shall fix the historical time period to be used to calculate the average historical volume of sales revenue and use such period for all disclosures purposes for all sales-based financing products offered by the provider. The fixed historical time period shall either be the time period immediately preceding the specific offer or alternatively, the time period consisting of the same number of months with the highest sales and revenue volume within the past 12 months. The fixed historical time period shall be at least 1 month and shall not exceed 12 months. Provider using the opt-in method shall determine the estimated annual percentage rate, the estimated term, and the projected payments using a projected sales or revenue volume that the provider elects for each disclosure. On a finding by the commissioner that the use of projected sales or revenue volume by the provider has resulted in an unacceptable deviation between the estimated and actual annual percentage rates, the commissioner shall require the provider to use the historical method. The commissioner may consider unusual and extraordinary circumstances impacting the provider's deviation between estimated and actual APRs in making such finding. Any questions? Okay. You're further requiring that you need to show them the total repayment amount, which is disbursement amount plus the finance charge. Section E here also requires the estimated term as the period of time required for the periodic payments based on that projected sales volume equal the total amount to be repaid. F, the payment amounts based on the projected sales volume for payment amounts that are fixed, payment amounts and frequency, and if the payment frequency is other than monthly, the amount of the average projected payments per month. Or two, for payment amounts that are variable, a payment schedule or a description of the method used to calculate the amounts and frequency of payments and the amount of average projected payments per month. Do also have other requirements here. So G, a description of all of other potential fees and charges not included in the finance charge, including draw fees, late payment fees, return payment fees. Section H, were the recipient to elect to pay off or refinance the commercial financing prior to full repayment, the provider must disclose whether the recipient would be required to pay any finance charges other than interest accrued since their last payment. If so, disclosure of the percentage of any unpaid portion of the finance charge and maximum dollar amount the recipient could be required to pay. And two, any additional fees not already included in the finance charge. Description of collateral requirements of security interest, if any. Let's see, the provider shall obtain the recipient's signature on the disclosures required by this subsection before finalizing the application for the sale-based financing. Do you want this disclosure to be provided before they advance any funds? Let's see, paragraph 3, a provider shall not provide sales-based financing to a recipient without first provide, oh, sorry, I just read that. Must have turned. Paragraph 4, the commissioner may prescribe the format for the disclosure required by this subsection. And so that's one of those items that we'll need time to work on. Paragraph H, there's a whole section on disclosures for the factoring transactions. And it does say, provider shall provide the following disclosures to a recipient at the time of extending a specific offer for a factoring transaction. A is the amount of receivables purchase price paid to the recipient, and if different from the purchase price, the amount dispersed to the recipient after any fees are deducted. B, the finance charge. C, the APR. Again, we're using the same regulation, the Truth in Lending Act, but a different section. Section 1026 Appendix J as a single advance or single payment transaction, regardless of whether such act or such regulation would require such calculation. We go through how to calculate it here. The purchase amount is considered the financing amount. Purchase amount minus the finance charge is considered the payment amount. And the term is established by the payment due date of the receivables. There's an alternate method of establishing the term. The provider may estimate the term for a factoring transaction as the average payment period, its historical data over a period not to exceed the previous 12 months, concerning payment invoices paid by the party owing the accounts receivable in question. We also require the total payment amount, which is the purchase amount plus the finance charge. And E, a description of all other potential fees and charges that can be avoided by the recipient. And F, a description of the receivables purchased and any additional collateral requirements or security interests. Paragraph 2 also requires the signature before disbursement. Paragraph 3, a provider shall not provide commercial financing to a recipient in this factoring transaction without first providing the disclosures and obtaining their signature. And then let's see, paragraph 4, again, the commissioner may prescribe the format of the disclosure required. Questions on any of that? I know I'm just reading it, but it's the first time you've seen it, so. Appreciate it.
Yeah, go ahead, John.
I should go back to E, a description of all other potential fees and charges that can be avoided by the recipient. Is that something that we see in a lot of other areas of legislation? That is a sort of considered disclosure, or is that?
Yeah, I would think in general, if you're looking at just a traditional loan product, it's going to say what the late fee is and when it's due.
That's where we are. Okay.
Yeah, I would say if there's a return check, what's going to happen there.
So it's avoided via behavior or activities after one secures it, not in the terms under which you might engage in. Like
that's what I think we're trying to capture with that one.
Thanks.
And before that, we're asking for an amortization schedule and legalese, basically.
In legalese, based on the fact that we're talking about estimated sort of, yeah.
And the difference between that C and what we had gone over earlier in the bill that had another reference to the truth in lending, where you were talking about it expressed as a yearly rate. It sounds like there was a little bit of difference in the language, and that's because it's coming from different parts of the.
That's because we're talking about, in this language in C, we're talking about factoring transactions, so it's a little simpler, it's more known. We have that receivable that you bought at a discount. So it's a little easier to do the calculation, whereas with the sales-based financing, it may fluctuate, there'll be the true-up mechanism. So inherently, we have to make some estimates, correct?
And so the CFR provides for those. Is that it? That in one instance you're talking about an appendix, in another instance you're talking because they provide different.
Yeah, each section has a different methodology for different reasons and different types of lending.
So on this factoring, it's almost, I'm trying to think about it like in layperson terms. It's like a layaway program or for a business kind of a thing where you're paying, you have not really layaway, but I guess it.
Yeah, I
But
mean,
you're buying it on credit, you have the opportunity to sell it.
yeah, you're a business, you sell something, you provide terms to the customer to make the sale. They're gonna pay you in 3 months. You can get your money today by accepting a little bit less than what the customer is going to pay you for that transaction. It's essentially been sort of purchased by that provider.
And there's a way to do this today that is following DFR rules, and we're trying to close a loophole where people are doing this, that they are not licensed to do it, or is there not a way to do that today that's legal?
This activity is going on today.
Yep.
There's no way for DFR to regulate it as a loan product without this statute.
Okay.
Does that make sense?
It does. I'm trying to understand the practical implications on a business on this, and I'm wondering. Yeah, somebody sees a product that they want to try out in their store and they only want 50 to test. And so they're gonna, so the person who's selling could, say, I will give these to you at a lower price and you pay me back more after you sell them, kind of a thing, right? That's what this would be. Or I'm gonna give you these and you pay me back the full amount later. I'm just trying to understand exactly.
Are you talking about the,
Early, and I'm,
yeah, I know it is early and I
clearly did not get it.
You reread the same thing twice. I don't know if we caught it.
It's all right. So I think going back to the first part of your question, I think the practical implications for a business that's operating in Vermont now is that this will mandate that the person who wants to provide financing to them has to disclose a lot of things about the transaction to them now. Right now, there's nothing that does require that. The providers may already be providing some information about that, but it is not a DFR regulated transaction. So we're not able to mandate anything be disclosed, whatnot. Does that help with the first part of your question?
It does. Yeah. That part I get.
Okay.
That part's clear to me. I'm just trying to, let's talk about widgets and how this would work so that I can visualize it in this form.
Sure. So
Or in a business.
if an implication may be that if there are not licensed providers, that they will just stop providing that service. That is always a policy thing you should consider.
But there are reasons for that. And if a financial institution or lender that's licensed doesn't want to complete that, make that kind of credit available, it's probably a reason they don't want to take the risk.
There's probably a reason they don't want to comply with regulation, yes.
Yeah. So
It's not like, it's not the coffee shop that has a local baker that they're, baking 5 dozen muffins for them and they pay them back after they sell them. This is not that.
Probably not that small, but we have seen like, I believe there was someone who was a landscaper. And he had a landscaping business, and so he obtained some financing through one of these sales-based transactions. And so, he was having this money coming out of his paycheck, out of his deposit account, as those receivables were coming in, and it was pretty harmful. So it may not just be like a named corporation that's doing it, but it could be a smaller sole proprietor. It could be a store owner like Chair Marcotte. It could be a very different sort of or a wide variety of users of the service.
Yeah.
Yeah, and the way I'm looking at it, and there's no specific, other than personal use transactions that might come within this. There's no limit on, or is there a limit on the rate of interest for these transactions?
That's a great question. We did not put in a
That's okay.
statutory limit or usury rate for
Right.
the transactions. And the rationale that we were thinking about was that for traditional lending with a loan to a commercial borrower or for a commercial purpose, there is no usury in the state of Vermont. You're exempt from usury in that person.
Right, so, I mean, the focus of this, as I see it, is mainly around disclosure. So that the landscaper knows what they're getting into, kind of thing.
Exactly.
There's some, I think, some additional, I think, important provisions around what happens when things go wrong, choice of law, arbitration,
Correct.
that sort of stuff.
Correct. It gives us the power to
The thrust seems to be, just make sure that these businesses know what they're getting into.
For sure. Absolutely. If you wanted to input some limits, you could, but just know it's not.
Yes. It's kind of regulation like.
Yeah.
I'm gonna start all over because I forgot where I was.
Well, thank you. I was out on the phone, so I missed.
Oh, okay. They approved everything.
Just waiting.
You're all set.
Okay.
Let's see. So under 4I, is that little I? Disclosure required if recipient required to pay off existing commercial financing as written. So this is a situation where we're envisioning that the business already has one of these, but they want to get more financing. So as a condition of that, the provider requires the recipient to pay off the balance of the existing commercial financing from the same provider. The provider shall disclose the following. And that is the amount of the new commercial financing used to pay off the portion of the existing commercial financing. That consists of prepayment charges required to be paid and any unpaid interest expense that was not forgiven at the time of renewal. For financing for which the total repayment amount is calculated as a fixed amount, the prepayment charge is equal to the original finance charge multiplied by the amount of the renewal used to pay off existing financing as a percentage of the total repayment amount minus any portion of the total repayment amount forgiven by the provider at the time of repayment. And 2, the disbursement amount will be reduced to pay down any unpaid portion of the outstanding balance, the actual dollar amount by which such disbursement amount will be reduced. So again, just disclosing exactly what's going on with this new financing. Paragraph J is the rulemaking section. The commissioner is authorized to adopt rules the commissioner determines are consistent with the purposes of this section or appropriate for the effective administration of this section, including rules connected to the calculation or determination of any metric required to be disclosed, rules necessary to develop and prescribe disclosure formatting to be used, so they can easily compare options in a clear and conspicuous manner. And such rules may include the designation and method for disclosing the information required in this article, for approving adequate forms and methods already used by providers, and rules that define the terms used in this section if the commissioner determines such rules are necessary and appropriate to implement and interpret. And let's see, I think, yeah, the effective date, this act shall take effect on July 1st of this year, except 59 and 60, which are July 1st, 27, which I already discussed.
So, do you want to go ahead?
I might be the same question. So, okay, so it says 2027. Okay, so basically, do you have enough time to do this with what we have for dates?
Yeah, we requested the year plus just thinking that we would need time to do the rulemaking. We have the infrastructure for the licensing requirements. That's easy, that's known, but it's just, we asked for the year for the ability to write some rules.
So for me, and I think it's because I was maybe not quite brain functioning at the beginning, I just want to make sure that there's nothing in here that allows someone who has one of these outstanding loans to modify it in any way without providing this regulation. So is the language in there that if there is one of these, right, a new one has to follow this regulation?
After July 1st of 27, that will be correct.
And any modification of one of these would also require this?
That's correct. That would be it. Any new. Yes, any modification would be a new transaction. So yes, that would be subject to the license.
I just want to make sure that's insanely clear. Maybe insanely is the wrong word, but perfectly clear.
I will make a note to see if we can.
So, and it
If
could
we
be
need
in
that
there, but
language.
I could have missed it as my brain was coming online.
Well, if we look right here on page 31, the amount of the new commercial financing used to pay off a portion of the existing commercial financing. So that's envisioning what you're talking about, like you already have one today. After July 1st, if you take out a new one, you have to do all of these disclosures in addition.
And that's where I was wondering, like you could perhaps just modify the amounts, and is that clear that that's new? I don't know that it is. Right?
With just modifying the
Modifying
existing
the-
terms, okay.
Yeah, any modification of existing terms,
I will bring that back.
maybe. Yeah, see if that,
Good.
other questions? Thank you, Aaron. That was a delightful way to start our Thursday. Today is Thursday, right?
It is Thursday.
No, it's only Wednesday.
Don't mess with me.
Let's take that do over. Chris, are you? You're welcome to stay with us, Aaron.
Oh, thanks. Thanks for warming it up. For the record, Chris Delia, President, Vermont Bankers Association. Good morning. This was mentioned to me by Chair Marcotte at the beginning of the session as an issue that he wanted to take a look at. He sent me the language late last week and took a look at the language, and we certainly don't see any problem with what's being proposed here for the merchant cash advances, if you will. Give you a little more context. I shopped the language around last Friday with our members, and then Monday morning I happened to have an executive council meeting. So I sat with them going over what's happening in this building. And I said, by the way, this might be coming up, and what were your thoughts? It sparked a roundtable discussion that lasted for about 25 minutes, which was that our bankers are seeing this type of activity in the marketplace. It often shows up in the financial statements of businesses, and it's kind of layered in there. So they'll have their traditional bank financing, but then there's some circumstance in the business where they need to or want to access capital. They'll get one of these solicitations that looks real good, and okay, so let's go ahead and get it. And then all of a sudden, the way they function, as Aaron talked about, they're reaching into your receivables, they're reaching into your accounts and pulling out the money for repayment. And overwhelming sentiment was at that point, it's too late for those businesses. They are really in a pinch. So in looking at the language, it doesn't ban these practices, but it does bring it into the light as far as regulation. And that makes an awful lot of sense. So we support what DFR is trying to do here in this bill. And you folks do as well. There's a lot of language there, but hopefully we can get it across the finish line here and over in the Senate.
Would you be able to maybe give us a little more layman definition of a factor loan? I mean, you're in the industry, so I'm wondering if maybe.
You know, I was as I was sitting there and I'm thinking, and this is not in the loan context, but we purchase tax credits in support of work that VHFA does in the marketplace, or downtown tax credits, whatever it may be. And that's sometimes 94, 95 cents on the dollar. So you're not paying 100%, but you're getting it at something less. And then flashing through my mind were sometimes the commercials on TV, J.G. Wentworth. Get your cash now. My money. You do a settlement and, you know, you want your money today instead of tomorrow. And I'm like, oh, well, okay, that's maybe there's some linkage there, but you're basically, yeah, as the business owner, basically, as I understand it, you need access to capital. They're going to give you a certain amount, but it's perhaps less than what you're asking for, but you're going to pay back a number because they've somehow discounted it or factored it in the negotiations. What seems clear from our banker's perspective is there's not a lot of disclosure as to what all of the fees are, how it's necessarily structured, and it's very easy to get yourself in trouble quickly. So again, what I think this does is bring that into light. So the factoring is just you're factoring it as a discount. So the business is able to get access to get that capital, but that's not the number they're going to repay to this entity. It's going to be something more.
So that difference is kind of the interest, if you will.
Yeah, I'm not sure whether it's called that, but
Right, that's why I
the
keep quotes.
interest, yeah. I mean, they're clearly making their money on fees and spread, if you will.
Emily, did you have a question? No, not for Chris. Okay.
No, that's doesn't make my morning. Come
I
on.
have one question.
That's my what?
How's your day today?
I don't know yet. It's early. Herb?
Yeah, I would think there's a provision, I mean, most of it's just disclosure on the part of these folks. But there is one sort of a substantive requirement that the agreement be go through the process as a security, perfected security interest. I would think that would be helpful for your institute.
Yeah, because
So you understand the priorities and where you sit.
because if somebody comes in and they want to access financing, the bank's going to do its due diligence, which will include searches in the land records for UCC filings and the Secretary of State's office for UCC filings. And that's how you perfect non-real estate transactions, if you will, in the marketplace. So those types of things, if they're evidenced by a filing, would show up for the traditional lenders out there if they're approached by this business,
There's some advantages to that kind of system. I mean, you say that it shows up when someone comes in to get a loan from folks. But that probably is not quite what the UCC requirement. Is there any advantage to having it within the secured, perfected securities interest, or having it in that realm? Does that help you folks in terms of being able to sort out
Yeah,
the risk?
absolutely, because again, you come in to a bank, you want to get a loan. The bank's going to go do a UCC search, and if this is now perfected under the statute, and there's a requirement that it's filed, if you will, with Secretary of State's office, that's going to show up when the bank does its search, and they're going to know that there is a loan out there. It allows them to make the decision, do they want to continue with the discussions and do the loan for you or not? That is important.
On arbitration, so I'm curious, your financial institutions, they have arbitration clauses? I'm not sure.
That would be above my pay grade until I have the chance to phone a friend.
Whether it references the Arbitration Act or the federal, because I know there's some differences.
I'd have to ask what's in the commercial contracts as to what they would follow.
That's fair.
More questions for Chris? Aaron, I have a question for you. I'm sorry.
Sure.
I thought I would just, the section about financing transactions of $1 million or more that are not primarily for personal, family, or household use. Can you talk about how that applies? Thanks, Chris.
Yeah, the $1 million component or the other?
Yeah, because the next part talks about if it's primarily for personal, family, or household use, it has to be treated a certain way. But it looks like it's up to $1 million. And I'm trying to, again, how does this work in the real world? What does that mean?
Today, if it's for personal, family, or household use, you need to be a regulated entity by DFR. There's not the $1 million component at all. So that limit would just mean that if this is a true commercial financing contract that's over $1 million, you don't need to be, it's not regulated by DFR. If it's under $1 million, it does. If somehow you're an entity and you're paying a little fast and loose with how you're providing these contracts to individuals or entities, and it's determined that it was for personal, family, or household use, then you would be subject to the requirements of the body of the law.
Okay, and then practical world, this is a business that has a home upstairs, something like that? Like what is that what we're looking at with this?
I don't even know if that would be applicable. I think it's just, and a lot of times you would have situations where there might be, it would be in the contract, usually says this is either for commercial purposes or this is not for personal or household use. I think we just wanted to include that to make sure that there wasn't a loophole that could kind of get through the cracks, so that if you did this and it was determined to be that you don't get the exception of the $1 million.
I'm not sure I get how it works in the real world yet, but thinking on that one.
Yeah, we don't have a ton of experience. Again, this is a body where we only see sort of the few bad cases that have come to us. And like I said, if it's a transaction with an LLC, it's going to be a little easier to determine that's probably for the business. If it's to Aaron Ferentz Landscaping, sole proprietor, it may not be something that's obvious that it's for a commercial purpose or not. So that's, I think, the reason why we included that language.
No, I'm thinking about the landscaping business that you got.
I just bought a chainsaw, so yeah.
Yeah, I'm just thinking about whether in that, and I think you implied that there was something about something that happened in that scenario.
There was one case in particular that I was thinking about, yes.
And I'm thinking about the $1 million, threshold, and whether that, I don't know the numbers involved, for that particular situation. The numbers involved, were they under or over or under the threshold?
The situations I've been have been drastically under that, but they've been I've definitely seen over $100,000 before. So
Million is a lot more.
million is high. So we wanted, again, that was sort of a carry forward from the commercial lender statute.
I understand.
So we don't have the regulatory requirement over that. So, the assumption is if you're able to borrow over $1 million, then you're going to have access to, and probably better knowledge and skills, et cetera, et cetera, et cetera, to engage in a transaction that is to your benefit and protect yourself from harm.
But then it would seem like maybe some of the smaller businesses are maybe more likely to engage in this kind of transaction.
And they will be subject to it because that's $1 million. If it's under $1 million, you're going to be subject to this law. It would only be if you're over $1 million. So if you don't want to, yeah, you don't want to increase it because that would sort of take out people from that. Sure.
Other questions? I don't have anyone else on the agenda to testify, but are there folks in the room that want to testify on anything that we just talked about?
If I can on the crypto piece.
No.
Colin Hilliard, Advocacy Director for AARP Vermont. Thank you for the opportunity to speak. I think want to acknowledge the good work that this committee and your colleagues in the Senate did last year in passing some really substantial consumer protections for crypto kiosks in Vermont. And we were happy to see the moratorium extension that was amended and put in the bill. We feel that's really important given the evolving nature of frauds that are perpetrated through these machines. I just want to call out some numbers so folks have an idea of just the growth in scams through these machines. The FBI's Internet Crime Complaint Center report just came out a couple months ago. And we saw a 23% year-over-year increase in complaints of fraud through crypto kiosk machines and a 58% increase in losses. American 60 plus reported losses over $250 million in 2025 in fraud through crypto kiosks. I know we don't have a lot of state level data for this. We only have 2 machines, right? But in other states, you're seeing substantial losses. And I want to acknowledge too that Indiana and Tennessee have both passed bans, Minnesota as well. Minnesota, I think, is really interesting to look at because that's a state that has had very similar consumer protections to us. And what they have 350 kiosks in the state, and what they saw was those consumer protections were still not cutting it. And so there's a push by law enforcement there to ban them. So we have real concerns, still even with the protections that we have real concerns about the harm that these fraud perpetrated through these machines can do. We had a poll that we surveyed older Americans nationwide, and 92% of respondents support protections for consumer protections for crypto kiosk related fraud and scams. And 8 in 10 perceive such laws as ways to support growth of cryptocurrency and not barriers to innovation. I think you all know what these scams look like and the harm that can be perpetrated through them. We just have real concerns of if the moratorium were to expire, and the ban language before you here is something that we would support.
So I think, thank you very much. And I think what I heard was that there's a 23% increase in the number of
Complaints.
A 58% increase in the
Losses.
So when they happen, then people are now losing even larger sums of money.
Correct.
The bets are getting bigger, the cons are getting longer, and the harm is outpacing the rate of incidents.
Yes. And
Average per loss.
average is increasing. And I'd also add too that, we know that the complaints are underreported, right? Pretty substantially. I think you've seen reports from like a Florida Sheriff's Department. And it's more than, the state of Florida had reported. And there's not really a good method of reporting this that rolls all the way up. And a lot of times scams perpetrated through these machines can go on for a really extended amount of time. Right. For example, a romance scam where you're seeing someone that is strung along for months and months. And so I think all those are factors, and the evolving sophistication of scammers, right, through this new method of a way to get money out of vulnerable folks.
Other questions? Go ahead, Emily.
Do you have a sense of the age of folks that are getting kind of stuck up in these?
The FBI's IC3 report does break crypto losses as a whole. I believe out by age brackets. We'll say that older folks, 60 plus, are by far and away the ones that lose the most amount of money. But everyone is represented, in that there's 18 to 24 folks that are losing money. I think a lot of that is due to the fact that, older folks have a lifetime of earnings to lose and a lifetime of savings. But that's not to say that younger people aren't vulnerable to these as well. And I'd be happy to share that the report and that age bracket data with you.
Yeah, that would be helpful. I mean, I think I think that we saw it, in the past, but seeing it again would be helpful.
Absolutely. Thank you.
Good morning, Heather Scholzeis with William Scholzeis and Associates here on behalf of CoinFlip. This was not the amendment that we were thinking that we were going to see, so I would like an opportunity for my client to be able to testify next week. But I do have a couple comments that I kind of put together quickly on the side. As you heard from DFR, there's been no reportable incidents. And we're talking today about one company, CoinFlip, that has 2 machines. The reporting and lack of fraud that's occurring, it's not luck. It's the result of your strong deliberations. We all sat here side by side with my client over a number of years, but passed the most stringent consumer protection bill in the country, which is now being used as model legislation. The framework is working, it's preventing harm, and it's now being looked at nationally. If there are concerns, then let's address the fact, not just a preemptive shutdown. Whenever you can regulate something, it's much better than a ban for the economy and for Vermonters. Let's give us time to engage in a serious data-driven conversation. It sounds like we don't have data to actually put us in a position to ban these machines. But I think it's a full evaluation on whether any adjustments are actually warranted would be important to do next year or next week, whenever you'd like to do that. But halting legitimate regulated activities that have produced no harm in Vermont since you passed your bill sends the wrong message to other businesses in Vermont, to innovators, and to Vermonters. I want to underscore Rep. Miklas's point. Vermonters should not be shut out of legitimate, regulated economic activity that is operating safely, responsibly, and under the very framework that you all created. So at the very least, I would like an opportunity for my client to come back and walk through this with you. But we were fully expecting, when we reached out to DFR in the Senate, that they didn't have time to go deep into this again, and so we'd kick it out another year. We agreed to that, and we hope that you will find the same resolution. And I know you're a committee of lots of questions. I'll do my best, but again, my client can help.
Certainly, I think Tuesday afternoon we'll take more testimony. we'll invite your client, or we'll invite you, you can invite your client.
Okay.
Thanks.
Thank you. Thank you.
That's good. That's it. Okay, so that gives us kind of the flavor. Aaron, can you just give us a general of what the amendment that Senate is sending over? We'll get that, we'll get that from Maria on Tuesday morning, but you can just kind of give us the overall.
Didn't prepare notes on that.
I think it was just, yeah, I think it was just a notebook and Abby's thing or something.
Oh.
Loggers.
Oh, it's my phone.
Oh.
Used to be your phone.
Yeah.
All right, Aaron
This
Ferris,
is an old phone.
Deputy Commissioner of DFR. So there were 4 amendments in the Senate version of the bill. I don't have it with me, but
Just kind of give us a general.
yeah, in section 1, there was just an instance where we missed the word registration. We were changing it to license, so that was one change. In section 22, that was where we were changing the definitions to make sure we were using financial institution very clearly. And so we changed it to person or lending institution. In that particular context, when we went back, we're like, no, actually, we want it to just say financial institution. So that changes. That's related to the Community Reinvestment Act, which is only subject to banks. They added a new section 14A, which was the extension of the moratorium, which gets modified with those amendments I just talked about. And then there was a section 48, which relates to our securities area. And it was just very specifically clarifying which section of the securities law it applies to. I think it refers to section 5302. They wanted to say 5302C. It was a very simple change. I don't know why, but it's in.
Right. So, again, we'll have this bill this afternoon, it gets shipped to us. I think it goes on notice. Right, tomorrow.
This it.
We don't notice, we don't notice today. We
No,
don't notice. Is it on?
it comes to us. It's from, the Senate passed it.
Right.
I will look and see if it's
Bill,
on.
but
That was today. I'm not sure.
So is it in this committee?
It will come back to us.
It will be.
well, I need to look because I believe it goes on notice, if not. And so we'll have to delay action on it.
Right.
For a couple of days while we work this out.
Yes, it's on the notice calendar today.
Yeah. So we'll delay action on it, probably 2 legislative days. Tomorrow. And we can work through this on Tuesday and get further testimony and decide what we want to do with this amendment and get it out there probably Wednesday. Okay. Let's take 20 minutes. Let's see if we can get Michael and either Abby, if she's.
He was presenting at 9:15, I think.
Yeah. So, and they're talking, I don't know that they. I think right now they were talking about. I think he's gonna get for 327. But they were on the floor at 11, so. I'd like, want to have some committee discussion again on that 71. So let's take 20, or let's just come back at 11, let's be here at 11. And, but hopefully everybody here, but Dave will be here, I hope, so that we can get that discussion going. So